Hi there, my name is Marla Neufeld and I'm a Florida surrogacy attorney. And today I'm going to talk to you about a question that potential clients have asked me throughout the years regarding sperm donation. And it's a pretty interesting topic. And clients want to know, or potential clients want to know, if they can classify a person as a sperm donor if the donor provides the sperm through intercourse, otherwise known as the usual and customary way of getting pregnant. So in this case, there would be no involvement of a fertility clinic, no turkey baster, the method of insemination would be through intercourse. Now, taking a step back, you have to realize that what classifies somebody as a sperm donor depends on the law of the state that is applicable to the donation taking place. Some states have sperm donor statutes that address what classifies somebody as a sperm donor, while some states don't have any laws on this, and you kind of have to piece together other laws to determine the parties' rights. That being said, there's no state that I'm aware of that would permit a person to be classified as a sperm donor when the donation is occurring through intercourse. Even the most liberal states, California and Florida, it specifically excludes insemination through intercourse. So some of the more lenient states do allow a donation to occur as long as the method of conception is not intercourse. For example, an at-home insemination kit where intercourse doesn't happen, but the sperm is transferred into the uterus via some kind of turkey baster method, even though the insemination does not take place in a clinical setting at a fertility clinic. Whereas some states are much more strict, such as Texas, and many other states that require the donation to occur in a clinical setting. So it could be very risky for somebody to do a at-home insemination, try to classify themselves as a sperm donor, even with the best contract in place, as that could be invalidated based upon the state law. So it's critical for anybody contemplating sperm donation to analyze the state law, consult with an attorney in the applicable state to make sure your rights will be protected, to have the proper contract in place, to follow the best practices of the parents having an attorney who typically pay for a separate attorney to represent the sperm donor, and for everybody to undergo mental health counseling to ensure that you understand your mental, kind of responsibilities and you think through those repercussions in being a donor. How do you speak to the child? What will the role be in the child's life as to the recipient and the donor? But as to my first question, whether somebody can have intercourse and classify them as a sperm donor, my answer to that is no. I think that is extremely risky under any state law. I do not recommend it. And not only is that risky from a legal perspective, but just medically, any insemination that takes place at home outside of a clinical setting is extremely risky from a medical standpoint because you're not involving a fertility clinic to do the proper FDA screening of the sperm, which is something that they do oversee when donations occur within a clinical setting. That being said, if you have any questions regarding sperm donation in Florida, please feel free to reach out to me. I'd be happy to speak with you, and wishing you all the best.